Hello and welcome to our webinar today. Our presenter is Don Mitkus, and he will be talking to us today about confidentiality and FERPA. I hope you enjoy today's webinar, and if you have additional topics you'd like to see covered in one of our webinars, please contact me at dale.gasparovic@prevention.org. Also, you can follow us on Twitter at SACenterPF, or you can email me to join our SAC group site. I'm going to now turn it over to Don to start our presentation for today. Don, it is coming your way.
All right, thanks, Dale. Okay, let's see here. Let me see if we can get our technology to cooperate. Showing the screen, fantastic. Okay, thanks, Dale. My name is Don Mitkus, as Dale mentioned, and I'm a consultant with the Student Assistance Center at Prevention First. And today we're going to be talking about working with students in regards to confidentiality, the mess that can occur in regards to confidentiality and how it intersects with the Family Education Right to Privacy Act, or FERPA. This can get to, if you've been a counselor or social worker or an SAP or a school psychologist or work in one of those capacities, without a doubt you have run face first into this issue at some point in your career. In either a minor or a major way. I just want to start out with a disclaimer. Even though we're going to be talking about some legalese and some statutes and laws, I need to let you know I am not an attorney. And even though my wife is an attorney, I am not one myself. And any issues that arise in your work that have, potential legal consequences or are legally gray by their nature require seeking the advice of legal counsel. So if there are any issues that come up that are in any way nebulous, or you feel put yourself or your district at risk of liability or negligence, you got to contact the attorneys that represent your district and get their advice on how to proceed. So the goal of this presentation is to provide a basic understanding of the complex issues of confidentiality and what our legal and ethical burdens are as a helping professional. Because there are a body of laws, both federal and state, that govern what we can and how we can disclose information that is entrusted to us by our students when they come to us for help. So we're gonna cover those areas. We'll talk a little bit about the federal statutes. We'll talk a little bit about the state statutes. We'll talk a little bit about how they conflict in some areas, and what's your best, what are your best guides. The laws and statutes and such are there to provide guidance on how to protect the integrity of the mental health of the people that we work with. So the laws are there for a reason, and we do need to do our utmost to abide by those laws, because they have been written or have been enacted in the best interest of the individual who is seeking help. So with that, and the reality of our work with students is, if we work in a capacity to provide counseling in a school setting, as I mentioned, we will inevitably come to a time where our duty to the school and our responsibility to students will come into conflict. The times that we've had something as minor as a teacher coming to us when a student is out for whatever reason, could be medical, could be a family vacation, could be that they're in some form of structured treatment, inpatient, a day program, residential. That teacher coming up to the counselor or the social worker and saying, hey, I haven't seen Billy in a week. Is everything okay? Now you are in a difficult situation. So where our duty to the school and that teacher's duty to provide an education to that student comes into conflict with our duty to protect the confidentiality of that individual. So what confidentiality laws govern mental health information? Well, there's federal laws. There's HIPAA, Health Insurance Portability and Accountability Act, the Drug and Alcohol Treatment Confidentiality Act, FERPA, as we discussed, and the Individuals with Disabilities Education Act, or IDEA. So these are the federal laws that govern mental health information and how it can or cannot be disclosed. Now the state laws, the big one is the Illinois Mental Health and Developmental Disabilities Confidentiality Act and the Illinois Mental Health Code. Our mental health code is, in general, the body of statutes that govern the delivery of mental health care in the state of Illinois, and the laws that all mental health care providers have to abide by. Other areas that touch on confidentiality include the licensing acts, those licensing acts that license people to be LCSWs or LCPCs or clinical psychologists, the Illinois HIV Confidentiality Act, the Child Abuse and Neglect Reporting and Elder Abuse Reporting Act, the Juvenile Court Act, and the Illinois School Student Records Act. Now, here's the thing: is that there are a lot of laws and statutes that touch upon confidentiality, and with all these laws, and sometimes they are not in agreement or don't align very neatly. So what is, for instance, HIPAA is very, very broad in some of its definitions of what can be disclosed, and is not very specific when it comes to mental health information. Whereas the Illinois Mental Health and Developmental Disabilities Confidentiality Act is very specific about under what circumstances you can disclose information. So as a general rule of thumb, if there is a federal and a state statute that govern, that touch upon a particular issue like confidentiality, your best course of action is to abide by the more restrictive law, the law that is more restrictive in how you can or cannot disclose information about someone's mental health care. So is a HIPAA, yes, there's some guidance there, but very much we would look at what guidance is provided by the Illinois Mental Health Code and the Mental Health and Developmental Disabilities Confidentiality Act. Those body of laws are going to govern us much more specifically on how we can disclose information. Some other sources of guidance include our ethics codes in our professional organizations. So NASW, the American Counseling Association, the American Psychological Association, all have a body of guidelines of ethical conduct, which also provide very specific guidance on how to preserve confidentiality. If you work for an agency, and the state agency includes a school district, each school district is different on how they have their regulations and policies written in regards to these matters, and they vary very widely. So it is in your best interest to seek out through your district what the specifics are on the regulations and policies in regards to releasing student information, in particular student mental health information. And then there are also private accreditation standards. So accrediting agencies also have standards in regards to disclosing student information, which can also provide some guidance on how to do that, or not to do that for that matter. So as I mentioned, the Illinois state law is pretty specific, and if you look at the specifically the Clinical Social Work Practice Act, which is State Bill 1507. If you want to read the whole thing, it's great for, it's better than Lunesta to help you get to sleep. But if you do want to read the whole thing or read the Illinois Mental Health Code, you can get very specific information. I've pulled out a couple of the salient points here. So in regards to the practice of social work, privileged communications, and exceptions. So it's no licensed clinical social worker or licensed social worker shall disclose any information acquired from persons consulting the social worker in a professional capacity, except that which may be voluntarily disclosed under the following circumstances. In the course of formally reporting, referring, or consulting with administrative superiors, so in the course of supervision, colleagues or consultants who essentially, if they are within the same organization or school counseling department and have the same licensure, you can, or similar licensure, so LCSWs can talk to LCPCs, psychologists, etc., for the purpose of consultation, who also share a professional responsibility to maintain confidentiality. So that's why you can speak to others that also are bound by these body of laws for consultation or supervision purposes. And then those people are also bound by the same laws, so they cannot then redisclose information that you may have discussed or consulted with them on about a particular individual. So in that case, it's you can talk to each other in a sense if you're all helping professionals in the same area. But if, say, for instance, the school, one of the assistant principal in charge of curriculum instruction approaches you and says, this student's been out for 3 weeks and I need to know what's going on with them. And they've been in a partial day hospital program at the local psychiatric hospital. Well, you're now in a situation where this does not protect you under the guidance of this particular act. You could not disclose that student was in a program or what they were being treated for. Or even give an indication that could lead that person to a reasonable assumption that the person was receiving mental health treatment. Because that in and of itself is the leading information is in itself a breach of confidentiality. So of course we'll talk a little bit about what's, who has the ability to control their disclosure in a second. Now, the State Bill 1508 provides protection for school mental health professionals from adverse action for preserving confidentiality. And if you want to look this up, this language is in there, and it's often helpful to preserve a relationship. The folks that are coming to you, school administrators, teachers, other school personnel, seeking information about a student that is absent, 9 times out of 10 are doing it out of a genuine concern for that individual, for that student. And when they ask and they're presented with the response they receive is, "I'm sorry, I can't tell you anything," often is taken as adversarial, and that they're acting in good faith and good conscience, and the helping person in the school, the counselor, social worker, SAP, psychologist, responds to them that I can't tell you anything. It can often be seen as, it's often taken as a rebuff and as creating an adversarial position. So it's a matter of how do you communicate to that individual that you can't disclose. How can you communicate that in a way that preserves the relationship you need to maintain with that administrator or that school personnel? And it's even trickier when that administrator happens to be your direct supervisor, is asking that information, because there are times where an administrator that may not be a licensed professional, might not have an LCPC and LCSW, but you do, and that is often the case. that administrator may not have that clinical licensure and is therefore not bound by these other laws. That you then can't have protection under the Clinical Social Work Practice Act, because they do not necessarily have that professional responsibility to maintain confidentiality. So ultimately you can fall back on the fact that the law of the state of Illinois does protect you, that you can't be subjected to adverse employment action, the threat of that action, or any manner of discrimination because you're acting in a way to protect communications as privileged or confidential pursuant to the applicable standards of professional responsibility, ethical codes, or relevant provisions of state or federal law. So if you're acting within the bounds of the law and the ethical standards of your professional organization, and the standards of the laws about communicating mental health information to others, that's in the mental health code, the law does protect you from being from adverse consequences from your employer. Now, with that being said, we'll give this caveat: pick your battles. Because even if they can't take direct action because of this law, they can make your life difficult. So again, don't necessarily carry a copy of this around and throw it in people's faces. It's a matter of know that you have the protection, and it can certainly be part of that discussion. But ultimately, you need to preserve the integrity of the confidentiality of your work with that client or student, and you have to maintain the relationships you have with the other folks in your school.
Hey, Don.
Yes.
Can you talk a little bit to the person who is not a licensed professional who may be sitting on one of these teams?
Yeah, that's a good question, Dale. It's the folks that are part of an SAP team, for instance, can be a wide range of folks from the school organization. It could be teachers, it could be other administrators, it could be a school nurse. There's any number of types of school professions that can wind up sitting on an SAP team. So in regards to there's actually not clear guidance in the law about how that professional communication is handled within the team. And honestly, I don't have a good answer in regards to the teamwork. The work of the team typically happens up until the point of intervention. And at the point of intervention, it's, the student is either referred on to a helping professional or helping organization. But prior to that, the discussion of the team is, that information is more governed by FERPA than it is by state laws. And FERPA does say that disclosure of information to other school personnel is permissible if that school personnel individual has vested responsibility in the educational matters for that student. So you can make an argument that FERPA covers what an SAP team is doing as far as talking to each other about a particular student, both during the information gathering phase as well as the intervention phase. All right. So just to define a couple of terms, definition of communication is everything. Any communication made by a recipient or other person to a therapist, or in the presence of other persons during or in connection with providing mental health or developmental disability services to a recipient. Communication includes information which indicates that a person is a recipient. So even acknowledging that person is receiving services is without their consent is a breach of confidentiality, or without consent is a breach of confidentiality. So record keeping. Any record kept by a therapist or an agency in the course of providing services, mental health services to a recipient, or concerning the recipient and services provided. It means any paper, electronic, video, audio, or other documentation, however and wherever it's stored. It includes intake information, progress reports, correspondence, evaluations, billing records, email, forms. Any information concerning that individual, concerning that student, is considered part of the record. Now, if it's part of the record, that this is also where FERPA and confidentiality gets messy, because the confidentiality laws in the state of Illinois protect that information that's kept by the record kept by a social worker or counselor or an SAP, but FERPA does not. According to FERPA, a parent has the right to examine any recorded information about their child that's in the school record. So essentially, good record keeping is essential. It's essential for many reasons. But anything that is in the record is potentially uncoverable by the parent. It really depends on what your school administration and your school district is willing to do to back an argument that it falls more under confidentiality than FERPA and denying a FERPA request. The exception to a record are personal notes. So a record doesn't include the therapist's personal notes if those notes are kept in that therapist's, counselor, social worker's sole possession for their own personal use and are not disclosed to any other person except in supervision or in consultation or with an attorney. Now, if at any time those notes are disclosed to any of those other folks beyond that, keeping them personally, they are then considered part of the recipient's record for the purposes of this act. So that means that you can keep personal notes, keep them separate, and they're protected unless you disclose them to another person for supervision purposes or for legal purposes. But once they are disclosed, they then become discoverable as part and become part of that student's record. So and there's certain things about personal. There's limitations on what personal notes can include. It can include the therapist's own impressions or speculations or reminders for themselves on I gave Billy a cognitive behavioral therapy worksheet to work on for next week. Make sure he's checking with them on next week. Information shared by a third party about the patient on condition it will not be shared with the patient. So your school social worker and their outpatient counselor calls you and says, hey, I want to provide you with a little information, but I also want to maintain that boundary between what you're doing, what I'm doing, so please don't let Billy know that I shared this with you. That can go in personal notes. And information shared by the patient that will be damaging to the parent-patient's relationship to a third party, if disclosed, can be part of personal notes. So if the parents are, if the family system is extraordinarily dysfunctional and the parents are gung-ho to get a hold of Billy's records at school, what has he been talking to that social worker about? We need to know because, we want to make sure Billy's not spilling the family secrets. Well, that social worker can keep that information in personal notes, but does have to keep them separate and does need to keep them, in their sole possession. So, a concern is, if I write these things down, and again, there's no rule of thumb. It's don't write anything down that you don't want published in the news that you wouldn't want published in the newspaper. But to be honest with you, the best practice is to maintain careful and comprehensive and accurate client records. It's your best protection. There's another old saying: if it's not written down, it didn't happen. So that means that as an organization, whether it's a school district or an agency or department, it really behooves you to have a records policy. So have a strict policy on how records are to be made and kept, and adhere to it. That provides you with protection that you're acting within the the auspices of your organization and your district, which provides you the protections that they can provide you. And if you're using appropriate professional judgment, the record should help you, even if there is a problem with it, even if for some reason the family or the student decides to bring a civil suit or something of that matter. If you've been working within the bounds of your licensure, working within the bounds of the ethical considerations, ethical standards of your professional organization, then you stand on solid ground, because then you have a record showing that you were acting within the bounds and limits of those ethical and legal considerations. And frankly, failure to keep records is questionable. If someone refuses to keep records, no matter what the reasoning behind it is, in any sort of legal proceeding, it can be viewed or construed as you've got something to hide, or you were not acting within the bounds of your within the legal statutes or within the bounds of the ethical code of your professional organization. And good, careful records are also potentially useful for the long-term continuity of care for that student. It might be needed later. It might be helpful as a helping professional to review those notes if you've been working with a student for a couple of years, to say, this sounds familiar. I think he was working on this. This came up sophomore year. Now it's senior year. Going back to those records, say, yep, and this worked. This didn't work, and can help guide how you proceed with that student at a later date. Or the information you can provide, the collateral information you can provide to another treatment provider with assuming there's a release of information, is extremely valuable. I've worked for psychiatric hospitals for years, and there's nothing better for when a student is walking through the door to be assessed and to be able to determine an appropriate level of care than having some good collateral information on what that student has been working on and struggling with, and what their progression has been. Because oftentimes when they get to us, they have a lot of the details tend to get forgotten or glossed over, or not mentioned, because going to a place like a counseling agency or a psychiatric hospital can be scary, and people will try to underreport. So having that information from this counselor or social worker can be vital in being able to determine an appropriate level of care for that individual, and we get our best information from those that have kept good records on the course of that person's issues. So under the state law, under the confidentiality laws and how they govern disclosure of information and treatment for minors, if a kid is under the age of 12, they have no right to confidentiality from the parents. So the parents are in complete control of how that information is, or if that information is disclosed. So and you cannot keep information from a parent or guardian of a child who's under 12 years of age. There's no confidentiality there, protection there. Now, minors, age 12 to 17, if the minor is informed and doesn't object, and the therapist doesn't find that there are compelling reasons for denying the access, the parent or guardian should have information about their treatment disclosed. Now, to protect yourself, for those over the age of 12, you should have them sign a release of information, even if it's to the parents, just to make sure that you have a written confirmation that they authorize the disclosure. Now, a minor, if you're in a situation where you refuse to disclose information about your therapeutic interactions with that student can petition the court for access to the record, and are frankly often granted that. But there are times, certainly, especially when it comes to abuse situations, where you want to be careful in what's disclosed to the parent that could potentially put that child at risk. Now, there are certain things that automatically should be disclosed to a parent upon request. That includes current physical and mental condition, diagnosis, treatment needs, services provided, and services needed, including medication, if any. Very basic, that they're physically intact but in a psychiatric crisis. That they currently they really need to go to the hospital in order to maintain their safety. In that they haven't taken their medication today. So those are things that can be automatically and should be automatically disclosed to parents. Now, also under the Mental Health Code of Illinois, a minor from under age 18 over the age of 12 can seek counseling services without the consent of a parent. Now, that is limited to 5 sessions. A therapeutic professional can see a minor for 5 sessions, but after the 5th session, they must disclose to the parents that the services are being rendered. The one exception to that is if the student is seeking therapeutic services specifically for chemical dependency. In the case where someone is seeking services, a minor seeking services for chemical dependency, they can see a therapist for an indefinite period of time without notification to the parent. So in that case, the notification of the parent that the services are being rendered is not required. It's suggested. It's highly suggested with the exception that the parents are not psychiatrically able to engage in a helpful therapeutic exchange with their child. For instance, if they're actively engaged in substance use themselves, or if there's a physical or other type of abuse situation, where to disclose that would put that student or that minor at further risk. The goal should be working towards getting the family engaged in the counseling or therapy with that student. So under FERPA, records are kept confidential, and permissible disclosures under FERPA include disclosures to school officials with, quote, legitimate educational interests. And this is potentially what covers the ability of the student assistance team being able to communicate with each other. Other disclosures include school where student seeks to enroll in a transfer situation, authorized federal, state, and local authorities, organizations conducting relevant research, or in a health or safety emergency. There's a health emergency at 911. Certainly there's stuff about the student you would be wise to disclose, such as current chronic medical conditions, medications, et cetera, et cetera. So again, in a health or safety emergency, may disclose personal identifiable information from an educational record to appropriate parties in connection with an emergency if knowledge of the information is necessary to protect the health or safety of the student or other individuals. So again, disclosing things that would impact how the care is delivered by those emergency workers is vital at that point. Now, a parent under FERPA can access records. A parent must be given the opportunity to inspect and review the student's education records under FERPA. And this is where FERPA and confidentiality run into each other head to head. Under confidentiality, a parent can only access records for a student over the age of 12 if that student is willing to sign a release of information or is willing to give consent, verbal consent. But again, ideally you want a written consent of release of information. in the circumstance that you're having those parents read those records.
Hey, Don, this is
Yes.
one that is kind of interesting to me because I'm wondering what qualifies as a student's education record. Um, because in my mind, that pertains to the permanent, quote, the permanent record in a school for their grades, attendance, etc., etc. Can you talk a little bit to if there is mental health information in that record, if that's
Well,
disclosable?
their education records do include anything that's held or recorded, as mentioned previously, what qualified record in that school building, not just the permanent record kept in administration and the big green binders.
Okay.
Includes the any progress notes or notes written by the school social worker. It includes it includes the data gathered by the SAP team to inform whether or not a student needs some form of intervention. So it's those sorts of things really should drive how you practice as a team. Do you keep those individual data collection sheets that you get from each teacher, or do you just keep a combined record and destroy those individual sheets? Now, keep in mind, if there's an active request in process for a record, you cannot destroy anything. So keep that in mind. It's actually legally actionable if you destroy a record when there's an active request that's been made. So it does govern how you practice. Do you just keep the combined data, so to speak, or do you keep those sheets that have all the individual comments and things of that nature? But anything that's written, unless it's a personal note, it is considered part of that student's education record. Okay. So testing they might have gone through with the school psychologist as part of the school record. Again, progress notes from the school social worker if they're attending some form of group or support group. Those things are all potentially discoverable or accessible by parents under FERPA, depending on how the school chooses, the district in their policy. And again, it goes back to what is your school district willing to support in regards to confidentiality laws and how they interact with FERPA, and are they willing to stand by, behind one of their student support personnel's stance that this is confidential information under the mental health code and therefore not discoverable by FERPA. And are they willing to stand by them, or are they going to say you have to disclose? It doesn't matter. And at what point, what kind of stance are you willing to take? When it comes down to it, essentially, your stance really has to be what is in the best interest of the safety and the integrity of the safety of that student. If there are safety issues, then it's something that you might have to stand your ground harder than you would if it's not necessarily a safety issue. So an imminent safety issue.
Thank you for that, Don.
Yeah. But here's the thing. What are the potential consequences of breaching confidentiality or refusing a FERPA request? Now, if the parents want to take issue with it and civilly pursue a suit against the school for either of these issues. Now, FERPA, the consequences for breaching FERPA are tied to school funding. The Department of Education can reduce funding for a school that refuses to comply with FERPA. That's the potential consequence. The consequences of breaching confidentiality laws are a lot worse for the individual and potentially for the school. breaching confidentiality, there's a potential fine involved, but more importantly, breaching confidentiality brings you to the attention of the Department of Professional Regulation, who will, in the event that that someone is found to breach confidentiality without cause, that puts them at risk for losing their licensure. I worked really hard to become licensed in the state of Illinois as a professional counselor. Spent years in school, studying clinical supervision hours, all sorts of, went through a lot to get this particular licensure. So I value it very highly. So breaching confidentiality without cause is, because a parent is hassling you, is not good enough for me personally, because I like having my license. The ways that confidentiality can be breached, or you can disclose information without a written consent of information by that individual, are very much related to safety issues. So if someone is imminently at risk to commit suicide, imminently at risk to commit homicide, you have not only the ability, but the duty to preserve life. So once someone states that they want to kill themselves and they have a plan and they have access to the means, or they want to kill someone else and they have a plan and they have access to the means, you have a duty to warn under both federal and state laws. So if you do not act to preserve life, you've now put yourself in a position of being liable for whatever happens. If you haven't had a chance, if you haven't had the Tarasoff case in California beaten over your head in graduate school enough, please review it. Tarasoff was a case about a psychologist that knew that someone was at risk to who stated that they were going to hurt someone, kill someone, and then they did nothing about it, and that person then went and killed that person. Which resulted in lawsuits, which resulted in this legislation. If so, you have a duty to preserve life. So if someone if someone discloses they are thinking of killing themselves and have a plan and access to the means, you have an absolute duty to contact that person's parent or guardian and get them help and 911 emergency services to maintain the integrity of their safety. If that person, if one of your students states that they're going to hurt someone else, that they have a plan to kill someone and have the means to carry that out and specifically identify that individual, you have a duty to not only keep that person keep that person contained, so to speak, where you're calling 911, calling the parent, but you also have a duty to warn that individual that they have threatened physical violence or lethal violence towards. Also, the Child Abuse and Neglect Reporting Act. We are mandated reporters. As a helping professional in a school, you are automatically mandated reporter. It's not our job to determine whether or not abuse has occurred. What our duty is that when a student reports to us that they've been the victim of some form of abuse or neglect is, neglect of their basic daily needs, not being fed, not being clothed, not being housed appropriately. It is our duty to make the phone call to 1-800-25-ABUSE and make that report. They may not take the report. They may not act upon it. Our duty is simply to make the call. We don't determine whether or not it's actually happening, but it is our duty to make the call. Now, the mental health, the Child Abuse Reporting and Neglect Act does not require that you inform the parents that the call is being made. That should be something that is discussed as a department, as a district, and in the policy. What is your policy in regards to reporting to a parent when calls DCFS is being made? and let that policy guide you in your decision making or how you proceed with that. So outside of those instances where essentially there are safety issues, imminent safety issues involved, confidentiality is pretty strict. And that's, it's there because ultimately the therapeutic relationship is predicated on trust. If there's no trust, there is no therapeutic relationship. And when people are trusting us with the pain and suffering and anguish that they are experiencing, if they're not able to trust that we are going to keep that in confidence, there's no disclosure, therefore no therapeutic relationship, therefore no therapy, no help, no counseling, nothing that will help that particular individual. So confidentiality really is one of the cornerstones of what we do as a helping professional. So some final words of advice. In any situation with a student, your first, again, I've said this before, but it's worth reiterating. In any situation with a student, your first consideration should be to maintain the integrity of that student's safety. Confidentiality, no confidentiality issue. If there's a safety issue at hand, you must act in a way to preserve the physical integrity of that student. And in a situation where it's a gray area, where FERPA and confidentiality are kind of butting up against each other in a particular situation, when in doubt, consult with your supervisor to access the legal counsel from the school district's attorneys. And they will, the attorneys, the school district's attorneys, their goal is to preserve the integrity of the district. So they are going to advise you to act in a way that will limit your exposure to liability. Ultimately, what their goal is to, and what they're being paid to do is to preserve the integrity of the district, physically and fiscally. So, and to reduce their exposure to liability. So it's if they tell you to do something, it's probably in your best interest to do so. And again, the reason we're providing you with this information is so you can have, not all attorneys are well versed in mental health law. So at the very least, to be able to have a dialogue about it, express your concerns, direct them to look at the legislation that governs these things, so they can also give informed counsel about how to proceed, how to act. So with that, if you have any questions or comments or concerns, you can feel free to reach out to me. This is my direct email and direct phone number. I'd be happy to discuss any questions with you, or if you need the name of a decent educational law attorney, there are a couple that we are fairly confident in, as well as if you have any need the name of a competent mental health attorney, we know those folks as well. Thank you for your attention, and I'll pass it back over to Dale.
All right. Thank you very much, Don. I appreciate the information you shared with us today. And I want to thank everyone for joining our webinar today. Look for more of our webinars on our website at www.prevention.org. Thank you.